who am I handing over to? Is it Stephen?
It's Boma, I thought. Boma.
Boma is around. So I'm going to hand over to Madam President so that she can say a few words of welcome. And just to note that this webinar is being organized by the Nigerian Bar Association SLP session and Broderick, Bozimo and co. If you don't know that, that's Isaiah Bozimo's law firm. So I'm handing over to Boma.
Thank you very much, Madam Prof. Moderator. Our job is really very simple, and that's to welcome all of us to this webinar. I'm really delighted to be here with the distinguished speakers that we have on board, and I'm looking forward to learning from this session. Thank you very much.
Thank you very much, Madam Chair and President. So, the way we prepared ourselves to proceed is we're going to have a couple of polls, as you can imagine. We have some young technology savvy people in the room, but we're primarily here to engage with the National Arbitration Policy that was published in the Gazette of the federal government in October 2024. And I'm going to introduce very briefly, just one sentence, our speakers, simply because all their profiles I have put in the chat. So if you click on any of those, you will be able to get additional information on who is speaking. But the first person we have is Dr. Olisa Agbakoba, OON-SAN. And this is because primarily, apart from the fact that Olisa arbitration, please put yourselves on mute. He's the major brain behind the policy. And then our second, I'm going to introduce Chief Anthony Digbe, SAN, Punica Chambers, who straddles Nigeria and Canada. And then our own Dr. Babatunde Ajibade, SAN. So as you can imagine, I'm going to be moderating a panel of SANs. I'm not an SAN, which is great. So that sort of brings a different perspective to it. My name is Emilia Onyema. I'm a professor here at SOAS, University of London. And so we're going to start. What we agreed is we're going to speak for a couple of minutes, just engaging with the policy, and then we would take questions. But if you have a burning question or comment, you can put it in the chat. We'll still monitor the chat, and please, a conversation can actually start on the chat. So I'm going to set out very briefly the key points or issues raised from the national policy on arbitration and alternative dispute resolution 2024. And the first thing to say is that this document is owned by the Federal Ministry of Justice. And so the Attorney General of the Federation is the rightful owner of it. But of course, he set up a working group that dealt with the policy. And a number of people within the Nigerian arbitration community had made comments on various iterations of the policy before this final version. I think one of the things we want to engage with is what is the mischief that the policy is trying to deal with? And in the context that in 2023, we had a new Arbitration and Mediation Act. We also need to be thinking, is the policy coming after the reforms of the Act, and whether that is the way these things need to be structured. And so the policy deals with the issues around Nigeria as seat of arbitration and as venue of arbitration. So all through the policy, there is a clear interest in ensuring that Nigerian institutions, Nigerian arbitrators fully engage and participate in arbitrations, particularly those that emanate from contracts or transactions entered into by MDAs. And those are government ministries and departments and agencies. And then talked about selection of arbitrators, talked about engagement of counsel. So you're beginning to see where some of these things are coming from. The idea being that we recognize we have qualitative counsel in Nigeria. Why isn't the ministries, the departments, the agencies, why isn't the government appointing these people, and how are they appointed? So how are counsel and arbitrators appointed, particularly in when it comes to transactions to do with the government? And then the other thing is the issue around a small claims court, even though it's sort of angled as though it's a small claims arbitration and courts and implementation. So we know that there's been lots of comments on this, and I'm going to also put in the chat an analysis done by our co-host for this event, which is Broderick, Bozimo, and co will put that. Falashade, if we can put the link in the chat, and so we'll start. Now, so in a nutshell, that is the content, generally, at a very high level of the policy. The panelists will unpack all of that for us. And the key question we want you to keep in mind is, does the policy solve all of these problems that it has identified, that the arbitration community within Nigeria has also identified over the years? And so, Folashade, can we have the first poll? So the first poll asks this question. Folashade, poll?
Yes, I'm working on it, ma'am.
Sorry. Maybe I speak too fast. Sorry. So the first poll. Okay. So while we're waiting on the technology, if you're all very comfortable using your digital hands, you can just sort of do raise your hand digitally. And the question we want to ask in the first poll is, how many people have actually read the policy? If you've read the policy, raise your hand. If you haven't read the policy, don't raise your hand, so that my counting can be easy. When you're in class, I hope you all know that I'm a teacher. So when you're in class, the teacher would say, show of hands. So if you have read the policy, can you please raise your hand, your digital hand? If you haven't, you don't need to raise your hand. That's absolutely fine. So we have, I'm going to tell you, we currently have 112 people. Thank you, Lorna. That's another way you can do this. You can do thumbs up in the chat. But we do have 112 people on this webinar. And so far, we're counting about 11 people, including myself, including, of course, Dr. Lisa Gwakoba, including Chief Anthony Itigbe. If they hadn't read it before, at least to prepare for this webinar, they would have read it. Okay. So a couple more people have read it. Okay, great, thank you. Which is really, really very interesting. And so we have a national policy that was published in October 2024. all over LinkedIn. You know, Nigerians are quite savvy on LinkedIn, and people have been talking about it. And we have a webinar by the Nigerian Bar Association SLP session, and we don't have up to 20% of those attending the webinar who have read the survey. Sorry, the policy. So we're hoping that when we finish unpacking it, it would at least raise some issues for you and you would want to read it. Thank you very much. You can now put down your hands. Thank you so very much for raising hands. Falashade, please make sure that the second and third polls are ready when we're ready to go. Chief Anthony Idigbe, where are you? Are you still Folashade? Okay, it's okay. Don't worry. It's fine. I will remember that one of the
I had a
Folashades.
little bit of
Very good.
problem, yes,
Oh, okay.
joining.
No, that's
So
absolutely fine.
I will send this link and I can't seem to be able to.
It's okay. Don't
check.
worry. We can see your face, so we know it's not Folashade. Okay.
Thank you.
So we want to start with you, and just to sort of help us walk our way and our heads around the interaction between policy and the legislation. Which one should come first? How do you engage with that? How do you deal with that?
Thank you so much. Thank you. It's a great pleasure to be on this panel, a wonderful panel. And I would like to commend the federal government for adopting this national policy on arbitration, which Professor Onyema has sort of given us a broad view of. I would, however, like to take a deeper dive into the objectives of the policy. And the objective of interest to me is the one that seeks to make Nigeria a leading and preferred hub for domestic, regional, and international commercial arbitration. And I say that this is actually a laudable and fascinating policy objective. However, policy is just what it is, what the government intends to do, and nothing more. And usually, government says what it wants to do in the form of a policy to either encourage or discourage a particular behavior or conduct, a trade, a business, or some other action. So this policy has been clear, as I've stated earlier, the objective, which is to make Nigeria a major hub for domestic, regional, and international commercial objectives. However, the policy must then state the steps to be taken to make that objective a reality. And therefore, the challenge with policy, outside the issue of the validity of the policy objective itself, is the implementation of the policy. It follows, usually there are three stages, three steps to ensure effective implementation of the policy. One, there must be an action plan, and then there must be implementation measures, and then a review mechanism. So I will just take those three issues, the action plan, the implementation action plan. It requires that there should be an owner of the policy. And as Professor Nyema said, that the Federal Ministry of Justice is the owner of this particular policy. So it's heartwarming to note that the National Arbitration Policy has the Federal Ministry of Justice as the owner. However, the owner must set up internal and external collaborative framework with other stakeholders, particularly the private sector and other MDAs, that is ministries, departments, and agencies. The owner must also be adequately resourced for the policy to be able to implement its action plan. So the second issue I mentioned is the implementation measures. This is the second element in the successful implementation of a policy. Now, reviewing the national arbitration policy, The implementation measures can be categorized into three. One, the people; two, the process; and three, the structure. So let me take the first one, the people. For the policy to be successful, there must be a pool of competent, skilled, and ethical and professional arbitrators, judges, experts, registrars, and other human resources. So it's one thing to say the objective of the policy is to encourage Nigerians to participate in arbitration, but it's another thing to have the pool of resources. Now, presently, from my analysis, there is a wide asymmetry among those professionals. Now, some are excellent and of international standard, but others are incompetent and unethical or don't have the knowledge. So the challenge is how to bridge the gap. This can be done through training and discipline. It will also require collaborative efforts across sectors and amongst the professions and the judiciary. And another way to improve standards and bridge the gap is actually to open the process to participation by non-Nigerian, internationally competent persons. So you see, like in Singapore, they will bring retired judges and all sorts of people to come on to improve the profile and help bridge the gap and fill skill gaps that may exist. So I go to the second issue, which is the process. Now, successful arbitration requires well-established processes in the form of clear rules. The Nigerian Arbitration and Mediation Act, AMA 2023, is a first-class law that, if supported by the appropriate jurisprudence, could make the process of arbitration in Nigeria efficient. Now, the policy owner, as part of the implementation process, should continually interrogate the process and have a legislative agenda to keep the process top class. Now, three, the structure. The national policy, I've reviewed it, is dependent on the existence of structures such as the Regional Center for Arbitration, the LCA, the LASIAC, and recently we just created the Asaba Chamber of Commerce Arbitration Center. Now, if, for instance, the policy refers to some sources of funding for the regional center, it is unclear how, other centers will be funded. Now, even for the regional center, the people problem is an issue. I've practiced before that particular center. So the people problem is an issue because they just assign civil servants, one director from the Ministry of Justice there. My suggestion is that it should be run by an independent trust. They should use the independent trust model rather than the civil service secondment model which they are using today. And then within the context of an independent trust, consider, what I said earlier in terms of people, bringing international people, help to bridge the gap and invest a lot in people and the infrastructure itself. So, and I think the last issue I mentioned is the review. So the last part of successful policy implementation is review. The national policy on arbitration provides for a review every 5 years. But this provision, although this provision is in line with best practice to review, as I've said, the devil is in the details. A 5-year review in a world that is very interactive today is way too late. It should be done quarterly and should be data-driven. For this to occur, there's a need for the owner to be more proactive. So it takes us back to square one, which is the action plan and the role of the owner of the policy. So in conclusion, I believe that if the above lessons on policy implementation are implemented, there is every reason why we must celebrate that Nigeria will be the leading and preferred hub for domestic, regional, and international arbitration in Africa. Thank you.
Thank you very much, Anthony. So you've sort of helped us to identify. We do know that the policy, it has an owner. And so the way you've sort of approached this, Tunde, I'm coming to you, so I need you back on the screen, please. The way you've sort of approached it is, okay, it's a very good policy. And I think Olisa will be smiling to note that the community will think it's a very good policy. The question then becomes, how do you implement any very good policy? And you sort of talked about people, process, and structure and review, that we need that, and you've engaged with that. I'm going to come back to you on some of those, because of course, the Nigerian legal community, for which part of which is arbitration, are very insular. They're very closed. They're very protectionist. And you're saying we need to open up. And you're also then saying that we need frequent review. And of course, there's another school of thought that says when you frequently review rules and laws, you then miss the whole concept or the advantages of certainty, of clarity. This is what we know, what the law is. We know what the rule is. But of course, no society stands still, and arbitration isn't standing still. We're making continual improvement. So we'll come back. We want you to come back on some of those to just sort of unpack them a little bit for us. And so thank you very much, Anthony. So we're now going to move on to Tunde. And Tunde, can I invite you to pick up from the perspective of a practitioner? You act as counsel, you also sit as arbitrator, you do both domestic and international, and you also do regional. So hopefully this policy should bring you more work. So, but from the perspective of a practitioner, what is your take? What is your view?
Thank you, Emilia. And thank you, Tony, for setting the stage so well. I think, you know, the policy is clearly pulling in the right direction. All of us arbitration practitioners in Nigeria, we're all intent on ensuring that Nigeria assumes its proper place within the global arbitration community, within the African arbitration community, and within the regional arbitration community. And I think, you know, just going to your question, Amelia, I think that's perhaps what I see as one problem with the policy, in that it is addressing slightly divergent objectives, but in one document and without splitting them out. So if we just look at it from the perspective of domestic, regional, and international commercial arbitration, there are certain things that you need to have in order to make arbitration attractive, right across board, across those three sectors. But I think the nuance that you would apply in order to make arbitration attractive domestically may not necessarily be the same nuance you would apply to make it attractive regionally or internationally. And to that extent, I think that the policy, fantastic document, but that distinction, I think, has not been drawn out sufficiently. And the other thing that I see with the policy goes back to something you said, and which Chief Idigbe picked up on, about who's the owner of the policy. Now, yes, the policy has to have an owner, and there's perhaps no institution more fitting than the Office of the Honorable Attorney General. But given the nature of arbitration, and given the importance of the role, for me, the biggest elephant in the room when it comes to arbitration is the judiciary. For arbitration to function effectively, you must have judicial buy-in in every sense of the word. And whilst the policy recognizes that, I think it's it's in its paragraph 15, that it sets out extensively what we need the judiciary, the Nigerian judiciary, to do. I think the real challenge is you can't, to borrow a colloquial phrase, you can't shave somebody's head behind their back. The policy, I am not clear in my mind that the policy is sufficiently inclusive of that critical sector, that is the judiciary. And when we were discussing, when we were talking about this webinar in our prep, I did make reference to engagements that we had when the AMA was being, when the push for the AMA to be enacted was at its height. And we engaged with some members of the judiciary, especially as it relates to the provisions in the rules of the AMA that seek to accelerate the hearing of arbitration-related matters. And these very senior members of the judiciary told us, I mean, in no uncertain terms, that you can't achieve this if we don't feel, we, the judiciary, don't feel that we are part of the process, that we are the ones actually pushing this. If you try to impose it on the judiciary from without, it's going to be dead on arrival. That's what we were told. And as a result, we made strenuous efforts writing to the immediate past Chief Justice of Nigeria to see how we could get the judiciary's buy-in. This was in relation to the Arbitration and Mediation Act. But I think the same sentiment, to my mind, applies to the policy. I think the policy is great. I think it's great that it has an owner. But I feel that we must do everything possible to get the judiciary to adopt the policy as its own and do all that is necessary without it being seen that we are prescribing, that the arbitration community is prescribing to the judiciary from without. The judiciary has to take ownership of this policy if it's going to achieve its laudable objectives. I mean, I'm sure there'll be details of this that can be teased out in the course of further questions, but that's where I'd like to stop for now.
Thank you so very much, Tunde. And I'm just going to ask you to start thinking through how do you think that the Federal Ministry of Justice, who would have leverage with the judiciary, how can they go about this? And what we're talking about is change in behavior. It's perception, yes, but it's also change in the way we behave. So Tunde, it's definitely not just the judiciary, because we have lawyers, some of whom, even the ones that are attending this webinar, who would have an arbitration agreement in their contract and still run off to court. And when we were prepping, I was telling you, which I have publicly stated, about an arbitration where since 2022, we have been injuncted from proceeding with that arbitration. And it can't possibly be right. And that's just one story. So all those who act as arbitrators on this call would have one or two or three stories of that. And so the question that I'm going to ask you to come back on is, can you pick up on how members of the Nigerian Bar Association, how lawyers themselves, what can we do to get buy-in from them into this policy as well? So I'm going to thank you very much, Tunde, for that. I'm going to then turn to Olisa. Lisa, you've heard Anthony, you've heard Tunde, you've heard the concerns. I think I would want you to not to respond, but to give your own view, because the work of a group of people is not one person's work. So even though it's built as a response, it's really not a response, because that's not you defending the work that you have done. But what do you think from what you have heard from Anthony and Babatunde? Please.
Thank you very much. Thanks very much. Well, I mean, clearly from the two earlier speakers, there's a lot of work to be done. But at least I'm very honored that we're looking at a policy. I'm very, very happy about that. So that's step one. But that's step one in a terribly long journey. And I'm happy that my brother Tony referred to implementation, which is very key. So part of what I'm doing as chair, if you look at page 17, I believe, you will see there's a structure, which I don't feel is as adequate as it ought to be, but it's there. Page 17 sets out the structure in relation to the membership of the arbitration committee. So part of what we are doing, and I'm happy that we're having this conversation, is to present in general issues and concerns. And I think one of the biggest concerns really is to have the buy-in of the larger judicial and arbitration communities. Just enough for people to produce a policy and then assume that it will work on its own. I just had a good experience as sole arbitrator in a major arbitration. And I sat idly by, doing absolutely nothing, whilst the parties were breaking their heads in court. So I asked, what was the need of my appointment as sole arbitrator? So we've got a long way to go. Got a very long way to go. I noticed that in the English system, contribute £2 billion to GDP. What do we contribute? So that's part of the discussion. It's very, 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 very at the very, very, very primary and early stage. But I believe this is a good document. I think Tony is right. 5 years may be too long, but because the Attorney General hopes to call a huge conference shortly to look at a lot of issues, in particular implementation, I think there's something proposed, the Attorney General, with the NJC, the National Judicial Council, because luckily the past gone CJ and I think 2 now, Onogen, had issued practice directions, but it's not really working. It's not really working. We still see cases, go to court and the judge is told there's an arbitration clause in this thing, so can you recuse or, stay pending arbitration? And like Tunde, my brother, said, it's still not, getting the sort of attention we hope that it would get. So I think that the forthcoming, I don't know when it will be. In my discussions, I know that there is a plan for a huge workshop conference around the big issue of implementation. So what we see, and again, there's another talk about to deal with the issue of structure. There's a talk about whether there'll be a need to create a directorate in the Federal Ministry of Justice, so that this has a day-to-day process. The closest we have now is the Directorate of Civil Litigation. I'm not sure how that will work, whether the arbitration thing will. Some talked about an arbitration commission, but we felt that was too unwieldy. That it will be better owned by the Ministry of Justice. What is required is to have a department that can daily manage the policy. Otherwise, it's just a document. It will go nowhere. So I hope that with the comments being made now and the updates, even that come out of the UK 2025 Act, we can even see that ours might even begin to need. I quite like the Section 6A that makes clear seat and governing law. Very, very important. That gave rise to a lot of conflicts. So that one now is resolved. I also like 39A, summary disposal. So you know when to bring an application if you feel that this is a matter that can be disposed of summarily. You see, I think you were asking that question, which one comes first, policy or the law? So I can already see ways in which even our AMA is already in need of some kind of amendments. So it's work in progress. Hopefully the Attorney General, because it's critical, the Attorney General has owner. It's so that that ownership is claimed and vigorously implemented. If the document we hold in our hands should have meaning. Without that active implementation, it will just be another document the government passes, another white paper that will just gather dust. So the hope is that in a very short time, the Attorney General will summon what he has described to me as something that would be very involving. So we can have a look at all, in particular, really have our judges, because that's where the problem is. Really, some say that maybe the arbitral process in the court should stop at the Court of Appeal, but does that make a difference? Does it make a difference? I think awareness of the judges that, look, we're not competing for your job. There's that, I don't know, in my discussions with the judges, they seem to be, you're taking our jurisdiction. No, we're not. We're unbundling and creating another door. It's a more process. We're creating another door to resolve disputes. And AMA has also now created more doors, mediation and all that. So it's an AD family. So if the judiciary were to, I'm doing cases in the courts that, in fact, I just did one, I think about, not me, not directly, but a senior counsel in our office. I think it's probably the oldest case in our law firm, something like 5 years in the Supreme Court. So we need to have this policy work. And the key for me is not so much to go through all the details, because essentially it's a good document. But yes, how do we make it works and does not sit on the shelves? So that's my contribution.
Thank you so very much, Olisa. That is very helpful. Folashade, can we have the second poll on the screen, please? We now have 124 people. So everybody is required to answer apart from those of us speaking. So we should be expecting at least 120 people to answer. Please, can you answer? And the question is really very simple. Whether Nigeria is an attractive seat for arbitration. And that is domestic, regional, international, because we've identified that that is what the policy is trying to address. Please, can you answer? I think we are allowed to answer as well. So speakers, if you please go ahead and answer so that everybody can answer. And so let's just, we'll take a couple of seconds to answer that poll, and then Folashade will tell us what the community in Nigeria, the arbitration community in Nigeria, whether you think that your jurisdiction is attractive. Olisa, there are a couple of things that I wanted to pick up from what you said. And this whole idea of it's the beginning of a journey. I think that is right. It's the beginning of a journey. I had read the policy when it was published. And yesterday, I couldn't find my copy of the policy. So I was struggling to find this policy online. And I went to Ministry of Justice website. I was just scratching my head because the only thing I could find was just commentaries by various law firms, and that wasn't what I wanted. It took me more than 20 minutes to finally get to the main document via the Ministry of Justice website. I think that's those are low-hanging fruits. Those are bits and pieces that we can easily sort out. And so maybe your committee, it might be useful to have a repository on the website of the Ministry of Justice so that it is there and events and comments are there. And so when work needs to be done, at least what the community is thinking will be clear. Thank you very much. So the poll has closed, and we saw so 40% on the call says that Nigeria is an attractive seat, and then 60% said no. So thank you very much, Folashade, we can close that now. So amongst those who said, out of the 40%, can any one person who voted Nigeria is an attractive seat, can you please raise your hand or unmute so that we can unmute you so that you can tell us why you think, from your experience, not that you're being protectionist. Anybody? Can anybody own and represent that 40% before we discount it? Anybody willing to say why they think that Nigeria is an attractive seat? Going, one. Going, yes. Going, two. Anybody? Going, three. Okay, so nobody can. Yes, Hamza. Hamza, can we unmute Hamza? Or Hamza, can you unmute yourself and tell us why you think Nigeria is an attractive seat? In 10 seconds. 1. Okay. Hamza can't unmute himself, so we'll move on. Amongst those, the 60%, can anybody tell us why they think Nigeria is not an attractive seat from their own experience? Anybody? Going? The offer is going. 1.
I can talk about it if you want me to.
No, we know you've already
Prof,
told us.
Prof,
Yes.
I can own that.
Yes, Agada, please. Yes, you're part of the 60%. Yes.
So for me, the major challenge today remains the judiciary and the support to the arbitral proceedings. We've got a lot of things right, but we still have a major challenge in bringing the judiciary on board. And I think that that's where the arbitral community or the arbitration community, practitioners, scholars and all that, we need to do some more work, because in my experience, no matter how beautiful the work we try to do, as long as the support that the judiciary, the seat of the arbitration should give it is not there, we are wasting our time. So that's thank you.
Thank you very much, Agada SAN. Thank you so very much. And these are practitioners in Nigeria who are talking and telling the community of their own experience. If you please feel free to also write in the chat of why you said no or yes, and we can pick up on that. And thank you so very much for participating in the poll. So we're going to now move on to the second phase of the discussion. And that second phase, I'm going to start with Olisa. Olisa, what do you think that your committee can do to just move things? You've heard, and I think we can all agree that what the policy is trying to do is make Nigeria an attractive seat for arbitration, yes, whatever that means for now. Domestic, regional, and international. So what do you think your committee can do? Then I'll come back to Tony. And Anthony, you're going to pick up on some of those questions that we left hanging and what, again, you think that the committee can do or that Nigeria can do. Then we'll conclude with Babatunde on what, again, solutions. Let's look at solutions. Olisa.
Yeah, sure. I think the first thing to think about doing is to give life to the policy document. Because as you just rightly pointed out, to my shock, actually, it's not online. So that's number one, awareness. Creation of awareness. People have to know about it, talk about it, organize relevant, like we're doing now, to popularize it. Because for me, a policy document is only a policy document unless implemented. So all of the problems that we've highlighted, all concerns we've highlighted, we need to begin to address it. I personally had recommended to the outgone Attorney General the need to have some kind of structure. I mean, you have a DPP in the Ministry of Justice, so he's responsible to manage the criminal docket. So I would want to see somebody, half of equivalentors, manage the policy on a daily basis. He comes to work in the morning, and that's his job. It's not just or we just do meetings or webinars. Somebody must carry the burden. The Attorney General is too busy to carry the burden. So since he is the owner, there'll be a very strong need, and that's the point I've been pushing. Somebody's got to carry the mantle of this job and move it along and deal with all the relevant stakeholders, NJS, the Bar Association, the arbitration community, and listen to what they are saying to give life, to keep improving it. Because to be honest with you, right now, you didn't want me to say it, but right now, I would not recommend Nigeria has a seat. That's just the truth. Because the constraints are far too many. So,
can I quickly say, Olisa, welcome to our club. There are quite a number of us who have publicly so said.
Okay.
So welcome to that.
Right.
Yeah.
But that's not to say I like it. That's not to say I like it. I'd like to see Nigeria turn the challenge is how do we turn this around? So I think the policy document is a big, but it's obviously not the end. There's a long way. So that long way is the issue that I think we can grapple with. And hopefully Latif, the Attorney General, would give me the audience to present all the views that we're canvassing and discussing.
Yes, thank you very much. And just a quick question before I move on to Tony. Did your committee, and forgive me, I'm an academic as well.
Yes.
Did your committee do any scoping exercise to just figure out, okay, what are the gaps? What are we trying to achieve? And come up with a reason, if you like, why we need policy. You did. Okay.
We did.
Perfect. And is that scoping work? Is it available online? Is it accessible?
No,
okay,
it's not.
And so you already cited the law commission here, the work regarding the 2025 English arbitration reforms to the English Arbitration Act. And somebody had also cited the 2 billion or 2.5 billion that legal services contributes to the economy of the UK. All of that information is because it's easily accessible online.
Sure.
And so that point that you made about awareness and accessibility, it's really important. So at least we can then engage from it objectively. Sure. And from a scientific basis. Sure. Did you want to say something else before Anthony comes on?
No, I've forgotten the point actually.
It's okay. When he comes back, just let me know, and then Anthony, please.
Yeah, thank you. Thank you so much. I've listened so carefully the various contributions. On the issue of whether Nigeria is an attractive seat for domestic, regional, or international arbitration, Dr. Agadas voted in support, but when he was called to speak, he spoke against. Saying that the
Chief,
problem
he voted against. He said it's not an attractive seat.
Okay, well, so
SAN, Agada, I will send you my bill for.
Thank you for that clarification. Now, but my experience is a little bit different, and I really want us to focus on it. I have had a very successful practice of arbitration in Nigeria. And I have actually earned a lot of money from it. And I know of many lawyers that have had successful practice of arbitration in Nigeria. and have earned a lot of money on it. And I realized that for some of those arbitrations, but for the leverage that's, say, the National Oil Company and some other few institutions have to be able to have Nigeria negotiated as seat of arbitration, we would have not had the opportunity to show our ability in arbitration, either as counsel or as arbitrators. We must understand that in terms of the global structure, it's slightly skewed against us.
Sure.
So, that having been said, I will personally encourage the seat of arbitration to be in Nigeria. And any policy that will assist in that should be supported by every well-meaning Nigerian. That's not to say there's no problem. I have identified significant problems. But like I said, when we talk about the people problem, it is beyond the issue of the judiciary. You have serious problems with even the arbitrators and counsel,
Council, yeah.
their conduct, their ethical conduct, their competence, and things like that. But then those issues also exist everywhere else in the world. So what we need to do is to up the game in terms of discipline, training, empowerment, and issues like that. And I think that that's what we must focus on. And that's what this policy, indicates the intention. And I believe that the government must have seen the potential benefit, both in terms of its a position when it's when it finds itself in arbitration, as well as the issue of directing resources back towards Nigeria other than moving it out. In fact, I did an arbitration recently in Nigeria, where, if you know what I'm not talking about the arbitrators or the lawyers, but the expert witnesses, what they wanted to charge. Eventually, we had to look inwards, and for the parties, all the parties, the cost was dramatically reduced by using local experts. So there's a lot that we can benefit. And the issue is, how do we harmonize our policies and remove policy inconsistencies? And then how do we make it sustainable through change in government and politics? I'll give you a good example. You look at the Lagos Court of Arbitration. Particular governor sets it up, maybe because he was a lawyer, sets up an independent trust. But as soon as he leaves, it was just left. There's no further support for that independent trust, and no proper investment in tooling, in skills, in the process issues. And then you see complaints in terms of the quality of support or arbitration administration coming from that institution. So we need consistency, policy consistency. We need a way to actually resource it. And so one of the things I'll be looking at is, how do we, make sure that there's funding, let's say from National Assembly, and I don't agree with the creation of more government institutions, maybe the arbitration commission and the rest, but a sort of partnership between government and private sector. Part of the problem, from my experience in Canada, the problem we have in Nigeria is the division between public sector and private sector. So private sector does not see necessarily in Nigeria their role as being stimulating growth of economic development driven by the private sector. So, for instance, here where you have a lot of what we call subventions and support. So the government doesn't create any institution; it just supports, gives grants and things like that. In Nigeria, the attitude at the public sector is that no, they will administer the grant, right? Meanwhile, they don't have the capacity to do it. The institutions are there in the private sector with the capacity, but they are idle because they don't have the funding. So there are lots of things that we need to do to harmonize the position between private sector and public sector, and the policy objectives can actually be achieved. And I want to end by saying that the best option for Nigerian arbitration practitioners is to develop a strong seat in Nigeria. And you don't do it by wanting to create an environment where you will cheat. You don't do it by trying to create an environment where you think you will be beyond any rule of law. You do it by creating a pool of highly skilled persons that will be attractive to people internationally as an efficient hub for domestic, regional, and international arbitration. One of the things you do is to scale it so that the vast majority of people will get their skills at the domestic level, and then they can grow to regional and international. At the international, it will be fewer people that will be playing. But I see a lot of people going for international arbitration training, international this, that. How many of them are going to get jobs at that level? We need to go. That is why we set up the Asaba Chamber of Commerce. At the domestic level, you do little things, and then you learn, and then you can gravitate to regional and maybe international. So it's how to plan the execution of the policy in a consistent manner to have the mass of the people doing the work at low levels, and in fact, the policy has the objective that okay, we have an arbitration register that will be dealing with the claims that are less than 5 million, etc. But there has to be a structure behind it, and then we keep a lot of our people busy doing those small work, and it will relieve the courts. Let me tell you, a judge is not supposed to be deciding little things of 5 million. He's supposed to be deciding big issues of constitution, of significant contracts and things like that, right? And at those lower levels, you can have those mediation centers and arbitration centers doing this, and people are getting the scale. And discipline must be a top priority for the policy to work.
Okay.
Thank you.
Thank you so very much. Thank you, Tony, for all of that. One of the key things that you talk about, and which is very, very close to my heart, is how do we develop domestic arbitration and institutional arbitration? And that is really important because ultimately, if we have a culture, which is what's working for us here in the UK, if we have a culture of resolving disputes and accepting the decision of the arbitrator, at least as starting from the domestic disputes, it becomes the way we do things. And that's what we were talking about. How do you change? And judicial intervention is basically what we're trying to say is that the judges should do that job for us by ensuring that you shouldn't be before me, get out of my court, and go to arbitration. That is what you have opted for. So before Tunde comes on, I notice that we have Professor Dorothy Ufort, we have Ms. Funke Agbo, all SANs and major players in international arbitration. And I would like them to just sort of prepare to say one or two things in less than 1 minute on this, on what they think. How can we turn this around ultimately? Tunde, please.
Thank you very much, Amelia. I think Agada seems to be the only person that's wholly on my side in putting the need for judicial support right at the top of the pile in terms of what is required to get us to where we want to go. And I'd like to drill down on that a bit more, because when we talk about the attitude, you just mentioned the attitude of practitioners in the UK or even litigants and their willingness to abide by decisions, etc. I don't think I don't think there's anything different between litigators or practitioners or litigants in different parts of the world. People will do what they can get away with. And that is why I think, I often draw this analogy. I said, if boxers were guaranteed to play fair, you wouldn't need a referee. If footballers were guaranteed not to, provide rough tackles, you wouldn't need a red card or a yellow card. The role of the referee is significant if you're going to have a fair game. And that is why I still say that if we don't get the judicial participation right, we're going to keep going round and round in circles. There is no way that you can stop lawyers from bringing frivolous applications, etc., except there is a penalty for doing so. And it is only the judiciary that can impose that penalty, either by way of punitive costs, or by way of disciplinary sanction. So if we have a judiciary that appreciates, my good brother, Jide Olagunju, mentioned the amount of money that the UK economy is making from arbitration. If we realize that this is actually a business and that we're in a competition with other jurisdictions to attract this business, and that we're losing money by not making our jurisdiction attractive, then we need to get the referees. The referees is the judiciary to get involved. We need to get them to understand what we're losing by not ensuring that the game is played properly. So, and there are two sides to this. The judiciary, because the policy also, there's a section in the policy, I can't remember, towards the end, that deals with training and talks about training both the bar and the bench. I think that is great, it's significant. But the culture that you've referred to, with greatest respect, is not something that you can be trained to do. It's something that you have to have an understanding of. So if you look at the commercial courts in the UK, who are the judges in the commercial courts? The judges in the commercial courts are people who were themselves typically high-flying arbitration practitioners before they went to the bench. So they're not going there to be trained on arbitration. They're going there with a full understanding of, if we don't get this right, our country is going to be losing money, our profession is going to be losing money. So you come into an English court with a frivolous application to stall an arbitration, you're going to get thrown out one, you're going to get hit with punitive costs, you won't try it again. And that is the signal that we need our judiciary to start sending. Now, can our judiciary, as presently constituted, do that? With the greatest respect, they can, because a lot of our judges don't have even a basic understanding of what we are trying to achieve. And there are a few courts, and why I'm so convinced that this is the critical problem is that there are some courts in Nigeria that are manned by people who were practitioners. When you read their rulings, I mean, I don't want to name names, but I mean, I can think of at least some judges in the Federal High Court, in the State High Court, in the Court of Appeal. I'm not sure of any in the Supreme Court, except maybe, but if you appeared before a judge who understands the ethos of arbitration, and you see the way they deal with this issue, you would realize that the problem is with the judicial support. Now, how do we get more and more of these judges to be the ones that will handle arbitration-related matters? That is another issue, because the policy talks about creating arbitration courts for arbitration. I think that is a fantastic idea, but I think it is not just labeling a court as, oh, this court is assigned to arbitration. If the judge sitting in that court is a judge who either is a specialist in land law or customary law or criminal law, the fact that that court is labeled an arbitration court is not going to solve the problem. So not only do we need to have arbitration courts, but we need to have those courts manned by people who are versed in arbitration culture. Anywhere in the world where arbitration is on a fast lane, I can bet you, whether it's in Paris, whether it's in London, whether it's in New York, those courts are not just arbitration courts, they are manned by people who are steeped in the culture of arbitration. So that is, for me, the direction we need to be heading towards. And that I think will be something that the policy, the owner of the policy has to take on board. We need to engage the judiciary in regard to this, and then we can start seeing some significant progress, in my view.
Tunde, let me come back a little bit to you. Do you think that maybe a commercial awareness on the part of the judges, in addition to, I mean, you know, for me, arbitration is all part of that commercial fabric. Do you think that that might be a wider and better way to frame this?
Absolutely. You know, maybe if we step back a bit, again, I've heard people say, oh, the courts are not functioning properly. And that's why everybody is, diverting to arbitration. And I laugh, because if you don't fix the courts, if you don't get the courts to function properly, arbitration is not going to be a solution. Because as everybody has said, ultimately, arbitration is not self-enforcing. You know, if you have an award debtor who knows that all he has to do is to bring some frivolous application in court and he can tie you up for the next 20 years, that's why many awards end up being settled out of court, because the award creditor gets frustrated and says, okay, you know what, just give me 10% of what I'm due, because I'm going to be here for the next donkey years. So unless we have a system where the courts are understanding what arbitration is supposed to do, and unless we ensure that the courts are willing to support that, we can't make Nigeria, we will not achieve our objective, which is to make Nigeria an attractive destination for arbitration at all levels. I mean, we have this quip, I can't remember who it's attributed to, who says that arbitration in Nigeria is a pre-action notice to litigation. And we just do the arbitration as a first stage, and then go to court for the real business before the delay starts. So we need to get past that, and we can only achieve that by making the courts understand that they should not facilitate that. They should understand what arbitration is supposed to deliver and deal with it decisively. So if frivolous applications come, throw them out, hit them with punitive costs, so that there's a deterrent.
Perfect. So thank you very much. I'm going to actually request, I know that the webinar is being recorded, but that a summary, a very good report is also made out of all of these comments, including those in the chat, and sent on to Dr. Agbakoba for his team. I think that's really important. I was going to ask if we have, Professor Dorothy, are you ready to say something? Looks like
yes.
you.
Okay. Yes.
Please.
Thank you very much. I wasn't hoping to say anything, but first, I want to commend the efforts of Dr. Olisa Agbakoba in bringing this policy to light. But I share all the sentiments that Tony Itigbe SAN has put forward. As an international arbitrator, I would tell you that international arbitration is very expensive to break into. And that is the more reason why for our next generation of arbitrators, this policy is very key. And like Tony said, leaving it for review after 5 years is too long. International arbitration is extremely expensive. And how do you get the work? And in a recent conference I attended, one of the challenges of international arbitration is that you have to pay to play. How many people from our community can play to pay? I give you an example. There's the IBA arbitration day coming up in London. I am going. There's the ICC Arbitration Commission meeting in Paris. I am attending. There is also the Paris Arbitration Week. That is a huge event. Now, I will tell you what all that is costing me. And in one of my last trips to Hong Kong, somebody really said, Dorothy, do you have to really travel up and down the world to rub shoulders to get appointed? And I said, yes. So when we look at this policy, the policy is critical. And I spent some time with Dr. Agbakoba when we were trying to make this policy come to light. But we need to take it further. Like Tony said, there are so many small arbitrations that our young people can get involved in. And another person said, one governor comes because he's a lawyer, he does this. We really need to focus to make this policy work. And I don't think we should do it in a way, I think in Nigeria, people see arbitration and arbitration appointment as, you're favoring somebody. It's not so. You're looking for the best hands, the best brains to put these things together. We really need to go back to the table and see how we can make this policy work. If we are serious about making Nigeria a favorable and effective destination for international arbitration, many of the people in our community cannot afford to engage internationally. It's extremely expensive. So we go around doing all of these courses, attending all of these conferences, because we have failed to, build ours. And you go to all of these places, I was texting somebody, okay, when you come to London, we talk about the opportunities, one of the new presidents in one of the institutions. But how many people can do that? So we are leaving what we should be doing here, building our structures. And I want to commend Tony for the Asaba Chamber of Commerce that has just been established. That is one of the things that we should be doing. He also talked about the Lagos Court of Arbitration, what is happening. But we are all racing towards international. Every conference, you see us speaking, but a lot of work is being neglected here. And that is where I really have to commend the efforts of Dr. Olisa Agbakoba. But we have to take it beyond the policy that has just been implemented. Emilia, you asked the question, did the policy come before the AMA, or the AMA came before the policy? So how do we align these things? There's a lot of work to be done.
Thank you very much.
I align myself with everything every speaker has said. Thank you.
Thank you so very much. Thank you, SAN. I had also asked Funke Agbo. I think she's unmuted.
Yes,
I have unmuted myself. Thank you so much, Emilia. Thank you for calling me. I wasn't really expecting to say anything, but I've really enjoyed listening to our panelists. I think this is a timely discussion, and I'm really excited at the fact that while, I'm one of those who are very, very wary of, Nigeria being a seat, because my experience has not been very good as far as that is concerned. But, when we talk about Nigeria as a state, I think more in terms of international. But I think the discussion should really, to be beneficial for the majority. It should really be about how to grow a domestic arbitration practice in Nigeria. For me, that is the focus, and that has always been my interest. And I think that, speaking to what Tunde said, absolutely, the judiciary has to be the gatekeeper for us. Because my experience is in the courts, and I see judges, I see cases that parties have agreed to go to arbitration, still being discussed in the courts. The judges are being thrown here and there, even to the point of appointing a sole arbitrator. You can go back and forth, can go on appeal, go back and forth for what? And just because the courts allow some lawyers who do this to continue to do this, which is absolutely wrong. So that culture, the culture of ensuring that people who are practicing arbitration, lawyers who are involved in, who know that when you have an arbitration clause in an agreement, if you have an arbitration provision in an agreement, and parties have agreed to arbitration, why are you blocking it? Why are you making it difficult to conclude this case outside the courts? And why are the courts also allowing lawyers to ensure that these cases do not close? It doesn't make any sense. So a lot of work has to be done with the judiciary. I don't know that it's training or anything. It's a culture. It has to be an understanding of this is a partnership, so to speak, with the private sector in ensuring that litigation or disputes actually come to a close. People are losing millions of money because they allow disputes to sit in the courts where judges don't understand the commercial ramifications of these sorts of things. Nobody's going to come to Nigeria to do anything if they cannot. The first thing any client will ask me, enforcement, how do I get my award? And I'm just stumbling half the time. All right, it's a long, nice thing, but honestly, I don't know. I just keep praying that it works with this particular judge. So a lot of work has to be done. I really commend the organizers of this seminar. I think this is a timely discussion, and I think that we have a lot of work to do, and we have learned a lot from this, and I think this would help in no way, in a lot of ways, for us to come to some kind of understanding of what the next steps should be, what the next urgent steps should be. Domestic arbitration for me is really key. Thank you very much.
Thank you very, very much, Funke. I'm just wondering if we have any judge on the webinar. And if anybody else wants to say something, it's just that these are, if you noticed on the panel, I think I was chosen as the token lady to moderate the panel, even though usually I'm much more than a token lady. So I needed I needed backup. So I needed to call my two sisters that I know very well to come and back me up. But if you do feel strongly about this and you think that there's something you would like to say, just let me know. You can put a message in the chat and then I would ask you. I didn't ask Agada to speak because he had already spoken. So those are really important. If there's any judge on, it will be really helpful for us to know. But one of the things that Odisa, that Funke and Dorothy have picked up on is this whole idea of growing the domestic market. I think that I get tired when we're always talking about training, because training is neither here nor there. For me, the key question is maybe if we can tweak the policy, let's start with the domestic. And then the MDAs they can have their own internal principles. So the policy talks about appointment of arbitrators, appointment of counsel, and even extends its limbs to investment. And so those who have international experience, it's important that we use what we have domestically. And, I don't know, but I have heard, and please don't quote me, anybody, because I don't know if it's true or not, on how MDAs appoint arbitrators and counsel. It depends on who you know, which is really, and we can see how that has not served the country well. And not just the country, but when these people go international, they disparage. It brings disparagement on the quality of legal provisions and legal providers that we have in Nigeria. And then those of us who know very excellent lawyers in Nigeria are left scampering and trying to counter what people can see and read from some of these judgments that shall remain nameless. But you know, it's important to think about that. I think maybe if we begin with domestic,
Yes.
rethinking domestic, and then for the MDAs, we also then add concession contracts and investment contracts.
Sorry, if I may,
Sorry, Tony.
if I may just, yes,
Yes,
thank you
please.
so much. If I may just say a few things around this issue that you have raised. I keep saying that when it comes to like the top ministries, the government, most of their transactions are likely to be international arbitration. You know, so when you talk about domestic, I would share experience we have had at ASEAC recently, and that should give the direction where we should go to, where we should go towards. So there's an association of borehole drillers, they drill boreholes, and apparently, you know, people engage them, and then maybe the water didn't come out, or there's a problem with the borehole, and they will go and report you to the association. And so what we're trying to do is to have ASEAC as the arbitral institution to now resolve that sort of dispute. You know, the borehole dispute, it won't be a lot of money, and it's a local and domestic issue. So we need a pool of arbitrators. And of course, we need the support. And the point is that they say they get a lot of reports because people don't want to go to court. They are not going to court. They report you to the association, and the association is trying to see how to sort of like manage that. And classically, that's actually how arbitration arose. That was how ICC was set up. You know, it was a couple of business people. If there's a complaint, they say, okay, you know, they just decide it on their own before they professionalized it, right? So at the very low level, that is happening now. But that effort, you know, we were talking about who the owner of the policy is, and that was where I said that there must be a collaboration between the policy owner and the other stakeholders. And it requires, at the domestic level, extensive marketing, a strategy, an implementation measure that involves marketing, getting all the trade groups together, making sure they have, you know, just like what AAA has achieved in America, very strong domestic arbitration and very weak international arbitration, right? So I have a friend in America. He is so busy. Why? He's doing the arbitration they sent to him, the maximum $2,000 credit card arbitration, because they put arbitration clause, and it was an idea to frustrate people from going to court in these mass tort cases, right? And they thought that the cases will not be handled in arbitration and the people will be frustrated. But the system has adjusted to it. He gets like 50 of those arbitrations. There's a fixed time that he has to do it, a fixed amount of money. But because he gets the volume, it's enough for him. He's comfortable, right? Very low level. But AAA had done extensive marketing to be able to penetrate, you know, that low level domestic arbitration. These are the sort of things that we need to do in Nigeria, and we'll keep our lawyers and our arbitrators, our experts, and the rest very busy at that domestic level. And then a few can rise to regional, and even fewer can rise to international. Thank you.
Thank you very much, Anthony, for that really important point. I've just put in the chat, the CIAB has what they call a business arbitration scheme. Or is it business arbitration or business adjudication, something, dispute resolution scheme? And they do exactly that. So they have small, you know, the Chartered Institute of Arbitrators has an arrangement with maybe different groups that would have bulk disputes. And most of these things will be documents only. And then they give you, there's guidelines on how the award can be written. And it's good way, it's a good practice on beginning to write award and things like that. I am hugely impressed that there's a trade union called, what did you call them?
Borehole drillers.
Borehole drillers. I mean, that is fantastic. Can you imagine if you can have a trade association for nannies and for, these are small things, but they are important. It's a question of volume. And I keep saying that in your arbitration agreement, in your CV, when you talk about your arbitration experience, maybe you've done small value 1,000 cases. That's a lot of experience than somebody who's done 2 or, just 3 commercial work. So I think that we can expand that. And Olisa, we've given you a lot.
Let me just jump in, if you don't mind.
Yes, please go.
I liked what Tony did, but I needed to ask him because a while ago there was this issue of whether arbitration ought to be on the exclusive list. In other words, the AMA, is it applicable across there? Because I know it's arbitration law. And I say this to tie up there's some noise somewhere.
Yeah, check the question.
Olashade, please, can you mute yourself? Thank you. Thanks.
I was just going to tie this up with Tony's point. I think in Delta,
don't worry, let me send her a message.
It is not me, Prof. It is not me, Prof. It's probably somebody using my login.
Okay, somebody else with Folashade. How many Folashades do we have? Our Folashade Banjo number 3. Please, can you, thank you for muting yourself. Okay, please, Olisa, carry on.
Tony, I believe that the time Bozimo and a local arbitration law was passed in Delta.
That is correct.
So this issue of whether arbitration itself is applicable across Nigeria is a big issue, because when Peter Obi was governor, I actually tried this workout. I tried to organize an arbitration center, because the volume of trade going in there and the courts were packed full with little cases, just as you mentioned. So I think it's something we need to be very clear about. What is the scope of arbitration in Nigeria? Would be important to assist in the development of local arbitration, as you have so described.
Thank you so much. Lagos State also has an arbitration law. It's not only Delta.
Sure.
Yeah, so, and also the arbitration center in Asaba is, well, and you can call it anything you want to call it, in the sense that it's a company limited by guarantee, and it was set up with the consent of both the Delta State government and the Attorney General of the Federation. So,
really?
we
why
call
was
it. Why
was the consent of the AGF required?
Because it's a guarantee company.
Right.
Require the consent of the AGF, and also as a matter of procedure, you also require because it's a Chamber of Commerce owned entity, you require the consent of the Delta State government. So we cover the whole field.
Okay, understand.
Thank you.
Understand. Yeah.
Okay, so thank you. So the real Afolashade, please, can we get the third poll ready? So this third question, what we want to find out, having engaged with the policy and thrown out various ideas on how we can deliver on the policy, we want to ask the last question, which is on whether we think that implementation of the policy would transform Nigeria into an attractive seat for arbitration. Folashade, is the poll ready? Yes, please. Please, can you vote? So the question is, do you think that the implementation of the policy will transform Nigeria into an attractive seat for arbitration? And we're looking at domestic, regional, and international. I think everybody can vote. And we still have lots of people on the call. Lashade, how are we doing with the voting?
People are still participating. Prof.
Okay, thank you. Okay, Olisa, there are a couple of comments in the chat around around the federal, I suppose, an offshoot of the fact that we run a federal system where we have the AMA and then the national arbitration, the domestic arbitration laws of the various states as well. And see how that would go. And then one of the other things that we picked up that is come out of the discussion so far is this interaction between public and private, and whether private providers can step in and what private providers can do. Okay, so what we have so far, whether implementation of the policy will transform Nigeria into an attractive seat for arbitration, 0%. So nobody thinks no, that it will not. 42% think yes, it will. 58% says maybe. And I think we would, that's to be expected, because if we're saying that the legal profession and the judges need to come on board and that there's so many other issues that need to be picked up, clearly a lot more needs to be done. And so we will conclude, you'll be happy to note, except somebody else wants to say anything apart from the speakers. Otherwise, we will conclude to say that what we've tried to do is we've tried to engage with the national policy on arbitration and alternative dispute resolution 2024. We have been able to clearly identify the owner of that policy. And we said it rests with the Federal Ministry of Justice. We've tried to unpack the policy a little bit and then to also engage with how it can be managed and some reviews. It does need some tweaking, and we've made various suggestions. And one of the things that has come out quite strongly is the need to make sure that we get the judiciary on board and to get litigators, so lawyers as well, on board. And it's really important that frivolous applications, all of those things, we need to appreciate that they are hurting Nigeria as a seat of arbitration, and they're making life a lot more difficult for all of us. The other major thing that has come out of our conversation this afternoon is the need for us to grow our domestic arbitration and begin to work on that culture shift. How do we shift that culture? And there's a lot, of course, to do with, we think about what we teach in our faculties of law. We think about what we teach at the law school, how we prepare our future lawyers. We need to think of all of those. We also need to think, we've been reminded that how do we select our judges and who are we selecting? It's a wholesale reform, if you like, of that sector. And we also then talked about the need for arbitration institutions. We didn't focus too much on them, but that is really an important one, that they are actually efficient. And we can use the Asaba Chamber of Commerce. I'm very happy with this trade union of borehole drillers. I think every state in Nigeria should have, because everybody provides their own water. So I think everybody should have that trade union, the trade association. They need to spread across the country. But that is a very good example. And maybe that's something that one of our young people on the call, you can do some research on that and write up something, maybe a blog or something that can be circulated for us to read, to learn what improvements are happening. And I'm going to, Folashade, who am I handing over to thank from the NBA, or should I go ahead and thank everybody? Folashade?
Prof, can you hear me?
Yes.
Okay. I think it's the SLP chair.
Okay. And does the SLP chair have a name?
Yes,
are you the spirit?
Yes,
You're Afolashade Banjo number 3. Okay, SLP chair.
I'm here, Professor Agom, the vice chair of the
Please. Thank you.
Thank you, the vice chair of the ADR committee of the SLP, and we're simply grateful to our resource persons for the discussion this afternoon. It's all about taking ownership of this policy. It's all about people and structure, and the recommendations made. It's time to hit the ground running. Let us walk our talk. And that's why the last part of this topic, from vision to action. Thank you very much, Lenel-Sik. Thank you very much, participants. We're grateful. And we all need to have our hands on deck to ensure that this policy comes to fruition. Once more, thank you very much from the ADR committee and from the section on legal practice. We're grateful and have a wonderful day.
Thank you.
Thank you so very much. Thank you. Bye, everybody. Thank
Bye.
you.
Thank
Thanks.
you.
Bye, everyone.
Yeah.